This is the Visions and Tones podcast with Dr. T.
Welcome to the latest edition of the Visions and Tones podcast. Today I'm talking to a very vibrant, lively young person, very much of a visionary. I cannot really recall when I've met him, but I know that from day one, meeting him, and I mean this from deep within my heart, I knew that this one was sort of destined for great things. He's going to tell us a little bit more about himself. But just as a bit of an intro, I'm talking to Mr. Katlego Makgaila. He is the founder and the managing director of Makgaila Associates Incorporated. Mr. Makgaila was born and raised in Limpopo in South Africa in a village called Tsimanyane under the Ephraim Mogale municipality. And he completed his LL.B Degree with the University of Johannesburg and is currently a candidate for the LL.M in corporate law with the University of South Africa. And just a little bit about his company. Makgaila Associates Incorporated is a law firm established in 2023 by Mr. Katlego Makgaila, and the firm currently has its principal place of business in Pretoria, Tshwane, that is in South Africa. Mr. Katlego, very weird for me to use Mr. Katlego, but let me see if I can survive that. Welcome, sir. It's good to have you on the show.
Thank you so much for having me, and good day to everyone listening in.
So I've read a little bit about your bio. Anything you'd like to sort of add on that? Or if you can jump on straight also to tell us more about your company. What exactly are you working on? You've now commemorated just 1 year. You've celebrated 1 year just about a couple of days ago. But obviously when we had a chat, you've been sort of planning to have your company up and running for quite a while now, which I knew basically that vision was basically on the pipeline, even if you had not told me, like I said earlier on, because I knew that you're much of a great visionary man.
Yeah. Just to add to that, we actually met in 2015.
Wow.
It's been quite a while.
I wouldn't even remember that.
We met in 2015. And yeah, it's been quite a journey. I've had the plan to start my firm from as far. I mean, when I got admitted, I knew that as soon as I've garnered enough experience, I'll be ready to start the firm. But I was ready to put the pen to paper in 2022, March 2022. And at the time, I was running another law firm. So I had a few projects that I was busy with at the time at that law firm. And when I was about to start, I've had a discussion with the director. He asked me to finish up the projects because he can see the well and they are going to succeed, but he would rather share the proceeds or the benefits or the fruits of my labor with me before I leave. And I was honored and I proceeded to do so. We saw the projects to finality, and in 2023, that's when I made it happen. And it has been quite a journey. Our biggest areas of specialty at the moment is corporate and commercial litigation. We also do contracts, interpretations, draftings, negotiations, arbitrations. We do that. We also do family law. Family law, I mean, we engage in custody. We do maintenance. We do your divorce. We also engage in advices around divorce. Sometimes you find parties are not ready to divorce. They just need guidance. They're having issues. Yes, we are not psychologists, but we guide them to the right people to say, look, these issues, perhaps you can engage in them first. I mean, it's very important that before we engage in this drastic measure, we give it a shot, because when we get to court, we also have to explain to the judge or to the court that we tried, the parties tried, and there's no prospect of reconciliation. But those are our biggest fields at the moment. We also have legal and risk compliance, whereby we assist companies in ensuring that they comply with all the applicable laws, predominantly your employment laws, your tax laws, obviously the primary legislation being the company law and the constitution itself. So those are our biggest areas of specialty. We are exploring or intending to also major in insolvency. It's part of my master's. Also engage in entertainment law. We've actually started dealing in entertainment law as well. So we continuously growing. We are continuously growing, and yeah, more fields will come as the time goes. When we commemorated our 1 year, when we celebrated our 1 year, we also established a satellite office here in Pretoria to major or specialize in third-party litigation, to assist those who need assistance with third-party litigation.
Sounds like a lot of things that you're dealing with there. How big is your firm so far?
At the moment, we only have 2 attorneys. It's me and the other associate, and we have 4 assistants, 2 drivers. So we are a total of 8 employees. I count myself as an employee before anything.
Well, we know for tax purposes, right? and any janitors already in your company?
So what we do in South Africa is that we work with advocates that we normally would call in-house, although independent, but we call in-house in the sense that these are advocates that we work with on a regular basis. We have about 6 of those that we work with on a regular basis. They're quite a formidable team, and I know every time I have to step up and go to court, defend a client, I'm in good hands when I'm with that team.
So if you include even people who help clean your offices, overall, how much is the staff, including those you outsource?
So fortunately, our office park provides those concierge services. They provide the cleaners for us. They provide our receptionist for us, and yeah. So those are costs which come with the office park.
Oh, nice. That's amazing. Yeah. Obviously, now you've sort of laid out for us a number of things that you do. I was keen knowing have you always had the passion to become, a lawyer, or this was a by the way, which you sort of also embraced it and it's sort of bearing great fruits for you?
Yeah. So when I was 11 years old, I think I was in grade 7. So I skipped some grades. Don't be surprised by the years.
Smart, yeah.
When I was in grade 7, I think I was 11 years old. Our primary school principal gave us a very great strategy in how you should approach your career. He said to us, you should have 3 options by area or by level of importance of what you aspire to do. My first option was being a medical doctor. My second option was being a lawyer. My third option was being a geologist. I remember when I was doing my grade 11, I applied. At the time, it was called Medunsa. I think it's called Katlego Makgaila Medical University now. I applied. I got admitted. They sent me the fee structures and everything, but I couldn't afford it. I didn't qualify for financial aid as well. So I had to take a bit of a gap year to structure things and plan with my parents. And the year later, during the year, I applied for my second option, which was law. I applied with the University of Johannesburg and they admitted me. And it came, I wouldn't say it was a by the way thing. It has always been a sort of a passion straight from high school, because even from as early as grade 8, I used to do public speaking. We do debates every year, but we do them every quarter. Our teachers would always ensure that I'm part of the teams that were in those debates. I even went as far as doing these debates on a national level, provincial level, district level. So it has always been part of me to stand up and represent people and their opinions and their views, I guess.
If you can pave your way for us, how are you sort of navigating the space in terms of mentorship and whatnot? I mean, most young people probably coming in the career, they might probably be having it hard. So how did you sort of manage to even finish your LL.B and then get a job instantly in a space where South Africa sort of grapples with high unemployment rate? So if you can sort of speak to us there, is there anyone who's been, carrying you on under the wings or what?
So when I finished my degree, I made it a task to find someone who has been practicing in the field for quite some time, and sort of sponge off them, to learn as much as I could from them, but to also observe others. I think one of my biggest ways of learning how things work has always been about observing others, seeing how they do their stuff, their approaches, seeing what works for me, and identifying what I think is not aligning with how I want to move. When I got employed, well, the first thing I did in the firm had about 15 attorneys, the first firm I worked for. And I started identifying those attorneys whom I believed shared the same vision as me. And they had been in the field for quite some time. The first one I engaged with had been in the field for more than 10 years. And I started learning from that person. I made it a task to learn as much as I could. And when I say learn, you don't sit back and wait for them to say, here's how you do this, here's how you do that. You must ask questions. In our field, the most important mechanism of learning is asking questions. And the biggest mentality to have is that I do not know anything. Ask. I do not know anything. And don't be scared of getting it wrong. That's how you learn. When I was a candidate attorney, when I told him that, look, you are going to be my mentor, I'm going to be learning everything I need to learn from you, I'm going to be bothering you, I'm going to be asking you a lot of questions, because when I finish my articles, I need to come out of this 2 years knowing all that there is to know. Yes, there may still be more for me to know after this, but knowing the foundation so that I know where to go after this. And he said to me that, look, you are going to get a lot of things wrong, and that's fine. When you get it wrong, don't be scared to come to me and say, did I do this right? How can I fix it? Where can I get this one? Where can I do this? How do I best approach this? So I can go as far as saying anyone who's still studying the LLB at the moment, find someone who you can, I'd say, learn from, but be open about it. Find someone who you can go to and say, look, I'm studying my LLB. I do not want a lot of things. I just want to learn. I just need to know how to go about this. I do not know anything. And it's the easiest mechanism to use to find yourself having a foundation. Even now with my master's, yes, I've been in the field for quite some time, but even with my master's, I still tell myself that I don't know anything. I continue to read, I continue to talk to people. I associate myself now with a lot of senior advocates in their respective fields, especially the ones that I'm studying in now. My master's is predominantly contract, insolvency, and company law. So I associate myself with a lot of senior attorneys and senior advocates who are majoring in these fields, who have been in it for like 15 years, 20 years, and I engage. I mean, a lot of the stuff I can read, but hearing it from someone who has been practicing it almost on a daily basis gives you quite a better perspective compared to just reading about it and translating it back into answers for an assignment or an assessment. So I would say the biggest pointer is that find someone and put yourself out there. Like I say, I continuously tell people that knowing your colleagues is your biggest commodity.
Amazing. I mean, obviously now I'd love to sort of have us get to the second segment, which is more about the discussion of today. I particularly chose marriage as the main thing we sort of can speak about today, because I've had a lot of people who've been asking me, questions, when are we going to sort of speak more about marriage, but also because I've observed a lot of mistakes that are sort of done by South Africans. For instance, those who do traditional type of marriages, not thinking even more about, signing up legal documents to sort of certify the marriage, and later on finding themselves, in the wrong side of life and reality. Why do you think the aspect of marriage is important, even much more in the context of your work?
So with regards to how marriage is done in South Africa, I tend to, when I have the discussions with my colleagues, I tend to say to them that I think there needs to be more education and information being given to the people. There need to be more workshops done, especially in villages, in townships. People need to be educated because the law, as it is quite complex. As we tend to say that there's a legal jargon, but there's also a way to simplify it, to bring it to the people so that they understand the contracts that they get into, because contracts are not only in the commercial sense. They are also there when we talk about marriage. Marriage itself is a contract, and there are provisions and legislations that apply, which the people of our country or the world in general need to be educated about. The reason why we chose to also specialize in marriage or family law, as I put it broadly, is so that we are able to educate people while we also protect their interests, in the sense that people approach us before they get married and say, look, I want to get married, but I hear that there are different matrimonial regimes. Which one works how, and which one do you recommend? And I would always say, we do not make recommendations, we always advise. The recommendation lies with you, or the decision lies with you. And we tend to say to them that if you decide you want to get married in community of property, the consequences are that you're going to have a joint estate. All the properties that are there, they are jointly of you and your partner. You are going to jointly own everything, including all your liabilities, your debts. If you know you have R1 million debt, you and your partner now owe it together. And we also indicate the consequences are that should it happen, which we never wish on anyone, by the way, but should it happen that you guys decide to separate, all of that is going to be shared jointly upon the two parties. We further advise that there's what we call out of community of property with the accrual system. And with that one, this is where
you're way ahead, way ahead of me. But I like that you're flowing. I want to take you a little bit back, maybe before you speak about the point you were going for now. If you speak about we have to teach, educate, whatever, do workshops with our people, I was just thinking at the same time, one of the things that I've noticed in South Africa, which is of great importance, is in acknowledging both the traditional ways of doing things and also the sort of modern or Western ways of doing things. It has to do with the line of medicine or healing. A place in Soweto where I did my master's, I found that there's sort of now a relationship that is built between nurses and doctors who work at a local clinic there and traditional healers. In the case where nurses and doctors cannot see anything, they're able to sort of refer the client to certain traditional healers in the area that they work with. So in the context of teaching that you sort of referred to, I was just thinking here, whether do you think also aspects of lawyers working with pastors that could be another good way? Because what I know is that most people are sort of open to undergo marriage counseling with their spiritual leaders, being pastors in this case. But at the same time, pastors cannot sort of unpack the idea of illegality in a sense that you as lawyers are sort of able to sort of unpack. And obviously, at the same time, there could be issues around doctrine, religious doctrines that might stand on the way. For instance, certain pastors might sort of encourage their congregants not to be open to issues of prenup and whatnot because those are not sort of showing godly love or whatever. Surprisingly, I've heard such arguments in the past. What would you say in terms of this? First, working hand in hand with pastors, is there room for that, or is not only with pastors? If we are to ever spread the teachings, which other avenues should we explore rather?
I think most of the time, before we even get to the legalities of all of this, parties are always encouraged to approach marriage counseling experts. It could be their pastors, it could be their psychologists, it could be therapists. We always advise them, but that also obviously gets to a particular point where it ends, and then that's where the legalities kick in. The pastors can only advise them on what marriage entails from a religious perspective. There are therapists, what it entails from a psychological perspective, mentally and emotionally, I understand. And we come in to explain the legal perspective, the consequences, because on our end, we see marriage as a contract. And therefore, it's important that we explain the consequences of any contract that you decide to take from a marriage perspective.
Right. So, but is there any do you see any light, though, working with pastors in a sense that pastors should encourage their congregants not only to just explore the idea of psychological or spiritual, but also to work with lawyers?
It is greatly, I highly recommend it, and I think there should be a room for pastors to actually advise their congregants or whoever that approaches them for counseling to also engage attorneys, legal practitioners in general to seek advice and to also understand the legal consequences of their marriage contracts. Although I understand pastors only have their own limitations, that's why I say they can only advise to a religious perspective. And up until such a point, that's where I would recommend that pastors advise their congregants to further seek legal advice.
Yeah. I think earlier on, go on.
I think we can work hand in hand in that part. I think that's also one of the most important ways to ensure that people enter into these contracts knowing the particular consequences thereof.
If you can speak to us as though you were speaking to a fifth grader, Tony, because you were I said you were ahead because you were now talking about anti-nuptial and whatsoever. I was like, I feel like you're way ahead. So what is a prenup, and if you can just take us from there, and what is a prenup and the explanation of in community and out of community? Just briefly.
Just to start with the prenup, a prenuptial contract is a contract entered into. Normally we would say it's entered into before the conclusion of the marriage, and this is the contract that sets out the terms of the marriage. This is usually what is used to include or exclude what we call the accrual system, which I'll also explain a bit later. An antenuptial contract is a contract normally entered into after the conclusion of the marriage, but normally within a particular period of time. If you do it, you should do it within a reasonable time, and if that time is no longer reasonable, you can do it through an application to the High Court for your antenuptial contract to be recognized. What we call an accrual system is what is used to determine normally how assets are to be divided or shared in a union or in a marriage. And to explain what we call an in community of property or out of community of property. When we say you are married in community of property, we are basically saying all the properties or assets and liabilities that both of you have become one thing. They become a joint estate that both of you are parties to, and all the consequences fall on the both of you. And all the liabilities and assets now are owned by the both of you jointly. So when we talk of out of community of property, there are two ways to talk on it. We say the first one would be out of community of property with the inclusion of the accrual system. Now, when we talk about out of community of property with the inclusion of the accrual system, this is where you're married out of community of property, whereby each party retains their own estate. You may retain your properties, you may retain further your liabilities as well. When we say we include the accrual system, is that in the event that the parties are to separate, we then assess how both these individual estates have grown. If I was to explain it to a fifth grader, I would say if you walk into a marriage, the both of you having 5 rand each, and you come out of it, party 1 having 20 rands and party 2 having only 10 rands, meaning one estate has grown by 15 rands and the other estate has grown by 5 rands. The accrual system is aimed at balancing the scales, in ensuring that now both parties must be at 50-50. We then have to look at it and say this one is at 10 rand and that one is at 20 rands. How do we then balance it? We then take 5 rands from that one and put it to the other one, and both of them are then at 15 rands each. That's the importance of the accrual system. Now, when we say out of community of property without or with the exclusion of the accrual system, each party retains their own estate and each party retains their own liabilities and assets. And in the event that the parties are to separate, anything that the parties owned individually remains their property. It normally happens that in such a setting or in such a matrimonial regime, parties buy assets jointly. They create sort of a partnership to buy properties jointly. And in such a situation or in such an instance, should it happen that they separate, they then have a discussion to say, we have these assets that we've purchased together. How do we then separate them? And how do we then make sure that we all separate in a fair and reasonable manner? But the estates or the assets and liabilities they came into the marriage with remains theirs individually.
South Africa is a multicultural country, and very often, whether it's with a critique that people are following colonization or whatnot, but at the same time, there's some people who follow customary. Can you unpack for us the distinction between civil marriage, civil union, and customary marriage?
Yeah. So with regards to civil marriage, we look at it in terms of the Civil Union Act, especially with civil union as well. And then with the Civil Marriage Act as well applies. And with regards to customary marriages, South Africa has what we call the Recognition of Customary Marriages Act, which helps to govern all the customary marriages. This arose as a result of the need to also recognize customary marriages on the wake of the fact that South Africa is a very, very diverse country. We have quite a number of cultures, groups of people as well. So it was very important that the law recognizes all of these cultures, and the only way to ensure that there's a clear recognition and there are guidances guidelines on how these marriages are registered and recognized, they saw the need to promulgate what we call the Recognition of Customary Marriages Act. The major difference is that with a Recognition of Customary Marriages Act, there are certain requirements which before based on certain traditions in different cultures. And with regards to civil marriages, there's only the requirements as per the legislation.
Right.
It is very important to highlight that a recognition of customary marriages primarily promulgates or results from the fact that we acknowledge what we call in mostly African traditions lobola. And what we call lobola is what we call a traditional marriage or customary marriage. Now, because of that, there was a need to create guidelines which would be recognized in the courts as to what constitutes a valid customary marriage.
Mm-hmm. I don't know whether from a sociological perspective I'll be right or wrong. Trying to sort of think, put on a legal hat. You'll tell me as the expert in the field. I would think, because obviously South Africa, when we speak of Civil Union Act of 2006, I think also it accommodated the same-sex marriages. Am I right or wrong? Yep.
Yes, you're correct. Correct. Yes.
So I would think probably same-sex marriages might. Yeah, actually, I might be wrong, but let me take a gamble with this point. Might sort of fit almost easily into like your civil marriage aspect compared to customary, in a sense that customary, there's a certain level of fluidity on things, in a sense of ownership of things and whatnot, whereas, if you look at the modern Western ways of thinking, issues of ownership has been taken much into consideration. I own this, I own that, and I need to have documentation as proof for this and as proof for that. I'm thinking more in terms of what can you sort of say with the complexities of, if ever there's anything to think about, there's the complexities of ownership of things in the context of customary whenever there's things that are not legally registered, but one knows that it belongs to this person and belongs to that person. But the courts very often does not necessarily work by that. We need evidence, right? Yeah.
Yes. So in most instances, just to start with the point on same-sex marriage, it was the Civil Unions Act was promulgated to ensure that such same-sex marriage partnerships further are also recognized as valid marriages or contracts. And you are correct to say they fit more into that than into customary law. But I subscribe to the belief that our law is a dynamic law. It changes and it develops as time goes. And I believe as time goes, customary law should also be able to properly recognize same-sex marriages as being valid marriages. And I believe we've made quite a lot of strides. The judgments as well have been coming in that assist in ensuring or recognizing same-sex customary marriages. And these are the ones that assist us in developing the law. Hence, I continuously say that our law is a dynamic law. But in respect of properties or assets which maybe don't have evidence that they belong to a particular party, it is very important to highlight that customary marriage is also automatically in community of property. And it is very important that an antenuptial contract is also concluded, or a prenuptial contract is concluded in that instance, to ensure that each party also comes up. Should it happen, or there is an event of separation, each party can then be able to come out and say, this is what I owned at the time, and this is what we purchased together, or this is what I purchased in my individual capacity and therefore belongs to me. And it is very important that the antenuptial or the prenuptial contract is entered into, because in the absence of such a contract, the marriage is automatically assumed to be in community of property, and therefore all those assets and liabilities are shared between the two parties.
Mm-hmm. One of the things I've been curious to sort of hear more, and this is a part where I'd love to hear what the law says, if ever, and also to get more of your critical faculty sort of fanning on us. It's the idea of cohabitation. I know that there's certain countries, if I'm not mistaken, countries like Canada, if you live with somebody for about 6 months and, you bought things together and whatnot, there's a certain clause that sort of will help at protecting both the parties. So there wouldn't be a way of sort of exploiting of one by the other. How's the standard of that in South Africa?
It has become quite prevalent lately in our courts, actually, recognizing that, because our constitution further indicates that we must also take note of international law. And when we take note of international law, we also look at countries like Canada to see, and to also look at other countries, UK, the US, you name them. And when we develop our law, we take cognizance of what works for the rest of the world and how can we best make sure that we are also not on the bad side of it all. Our courts have been recognizing cohabitation quite a lot lately. And this is also premised on the impression which comes up from a lot of our marriage legislation, which one of the most important requirements of this particular setups or settings is intention. So when you decide, just to take it a bit back, when you decide to live with a particular person, you intend to live with them, and the law says when you live with this person, you're either in a partnership, you're cohabitating, or there's an intention to marry. Now, all of these things must have a particular intention in them. And the moment we can establish this requirement of a particular intention, then the courts ought to recognize the cohabitation as being a valid union or partnership.
In the case there isn't any indication or intent to marry, because you should know most of the boys would rather sit with someone else's child for 7 years or until forever, because the title of "I'm married," it seems to shake the man,
In the event we don't have, or we are unable to establish sufficient intention, we are going to then look at your conduct. The conduct is that you live with this person every day for 6 months continuously. you have at no point said to them, I do not intend to marry you, please leave my house, or please leave my residence. So your conduct is that, explaining it to a grade five, your conduct is that you leave in the morning, you go to work, you come back, this person is here, you live with them, you sleep in the same house, in the same bed with them. It may not even have to be in the same bed, but you sleep in the same house. You are interacting with each other as partners. You are by conduct indicating that you are cohabitating with this person, and as such, there are certain consequences to that as well.
I mean, so in that case, then, of cohabitation, let's say people eventually decide we're splitting, how then does the courts work the idea of splitting assets?
In such a situation, it is first important to look at if there's any prejudice to any party. You'd find in an instance where one party was contributing predominantly financially, the other party was contributing by, for example, taking care of the household, taking care of there's a child, taking care of the child, also other issues in the house. Then the courts will have to apply what we call a principle of fairness and determine how the other party can then be put in a position where they would then benefit fairly without prejudice in the other client or the other party. In such a situation, there is no clear-cut approach. It's therefore looked at on case-by-case basis, whereby we determine the extent of prejudice and the extent of assets that were purchased in that particular cohabitation. But definitely the courts would look at it and ensure that there is no prejudice to any party.
So if you would remember sort of a case that dealt with that in South Africa in the courts, a famous case maybe, are you able to tell what kind of people normally drag each other into court yet they were in a cohabitation? Because I'm trying to think also about ideas of costs, right? If I'm not sort of making anything above 150,000 rands per annum, and same as my partner, one wouldn't say we're not that rich that we can drag each other into courts. Probably the idea of courts might even be more expensive for our incomes and so on and so forth. So what kind of people basically happen to drag each other to courts in that case?
It is usually the people who find themselves in situations where the other party, normally, if most importantly to highlight is that the courts don't just get involved. Parties come to court and say, look, I feel prejudiced. I feel like I lived with this person for 4 years. We were cohabitating. I did this and that. I was taking care of this and that. I helped him with his business by doing 1, 2, 3, and I believe I should be compensated for that. And the courts then look at the circumstances of the two parties' relationship from the beginning to the end and determine how this particular person's business grew and how this other party contributed to it. Sometimes it may be that there's been quite a number of cases, without giving a particular one in mind, in specifically, where you'd find that a business person was started a business as soon as they met with this person. They were cohabitating, they never got married, and the person's party business grew so much that while they were traveling around taking care of their business, for example, which is usually the wife who would be at home taking care of the kids, taking care of the household, attending to any family commitments in the absence of the husband, because it's usually the husband who's always away. Sometimes, yes, it happens that it's the wife, but it's usually the husband who's always away. And you'd find that the business now has grown from being a worth 500,000 rands business to being a 10 million rands, 20 million rands business at the time of separation. Then the wife would then come forward and say, I believe I contributed to the growth of this business by this method and this way. I delayed my career progression by taking care of the household. And therefore, had I not delayed my career progression, this is where I would have been. Usually in such a situation, we would have to employ the the services of an expert in such a situation, probably an industrial psychologist, to determine the career progressions of the type of a career the wife would be doing, to also assist us in determining how such a career progresses, at which particular age this person would have been, and which title they most likely would have been at. And such things help us determine the loss suffered by the wife, and therefore how much the husband would then have to compensate.
Wow.
So that's why I say it's dealt with on a case by case basis. It's the most important thing would always be the circumstances.
Wow, this is very interesting. I thought, a lot of people just take ideas of cohabitation very likely. It's just the case. On the point of alimony that I asked about earlier on, well, part of my understanding about alimony has to do with, if people divorce, and you've sort of mentioned that earlier in your point now, if people divorce and then the one who's disadvantaged, we sort of think about how can they be advantaged even in terms of the divorce and people having to pay. Because I wanted to ask you about that, as to how exactly do we get to the point of determining the fact that the wife has to pay the husband. Obviously, it might make a bit of a sense in the context of marriage, but I wanted to sort of unpack that in the context of cohabitation. So if I'm cohabiting with somebody and now the person, I'm cohabiting with somebody, the person has to leave the house, and then you bring your psychologist, they determine how much of a time I've wasted for the other party. In the context of civil or the modern Western way of thinking, I see to it that, well, probably it could be easy to determine that Tony should pay the other party. But in the context of, if we're thinking customary wise and putting in aspects of black tax, you might think that, yeah, Tony, you've got all this much money, you need to pay your other significant other. But what if from what I'm getting and being reflected on a pay slip or whatever income comes monthly, yes. I actually spend quite even a lot looking after, siblings and cousins in a form of black tax, but that does not have any sort of tangible evidence in most cases, right? Where in some cases I could bring evidence that here I paid for fees of my cousins, school fees of my cousins, and here's the receipt. But in some cases, black tax doesn't have any tangible evidence. So how do we unpack alimony in the context of maybe same way in the context of customary, but also in the context of cohabitation?
So we have normally, I would use it, let me phrase it in the context of a valid marriage contract. What we have what we call spousal maintenance and divorce proceedings, whereby if the parties are to divorce and the other party believes they ought to be, I would say, compensated, or rather put in a position where they would have continued to be had the other party not divorced them or had the other party not prejudiced them. And we then include that. Spousal maintenance comes in the sense that we then look at the circumstances. We would look at that Tony, or for example, whichever party, earns so much money a month. These are the liabilities they have on a monthly basis. And when we talk on liabilities, we're talking on fair liabilities. Tony cannot come to court and say, I am paying 5 rands to my sister's daughter every month because you do not have a maintenance duty towards your sister's daughter. Therefore, those that you have a maintenance duty towards will take importance, and they will then be considered before your sister's daughter. That's how we determine to look at that. You have your property to pay for that you live in, your primary residence, maybe your motor vehicle. You are paying medical aid, you're paying your policies. This is how much you're left with. And from how much you're left with, you are then also called to put it to the courts how much you can afford to pay. And the courts take into consideration how much you are able to pay on a monthly basis, and then the courts determine what they deem to be fair. Sometimes the courts may agree with you that what you say you're able to pay is what we deem to be fair, and what you say you are able to pay, we think is too little, and therefore we think this is how much should be paid. Or sometimes they can even go as far as saying what you are putting on the table is too high. Let's
Right.
bring it a bit down because we believe this is what is fair to be paid to this person as a spousal maintenance. And
Right.
it's important to highlight that spousal maintenance need not be eternal. One of the conditions is usually that should a party to the divorce remarry, then the spousal maintenance ceases. Because if you get married again, then you are in a position where we expect your partner or you and your partner to take care of each other. And therefore, that other party who has been paying maintenance, should they find out that you are married again, you are cohabitating with someone, or you are in a partnership, or you are in a civil union, they may approach the courts so that such a spousal maintenance can be put to end.
How about then in the case of the other partner who was disadvantaged and I was paying? Now they've got a job and they've got a promotion. Now their finances have ballooned even higher than me. How does the court interpret that?
So the whole point of spousal maintenance is to ensure that the lifestyle that you had accustomed your partner to, they continue with it. It may not be to the same standard or same scale, but they must not be too prejudiced to a point where they now find themselves, for example, having to start from scratch and they don't have anything. Should it happen in the event that the party you are paying maintenance to, um, their finances change, and they get a better job. They now have, for example, and they now start earning double the income they were earning when you guys were divorcing. You can approach the courts for what we call a variation order. A variation order, then you bring your case to court and explain to the courts that you believe you should no longer be paying the maintenance because this party's financial status has changed. They are now at a position where they're able to take care of themselves. And then you present your arguments to the courts, and the courts take it into consideration and pass a judgment on that.
I think I might have maybe one or two last questions, if I can exploit your time there, Mr. Makgaila. One is if you can speak to us about certain complexities which many people hardly think about. If I can give a case, let's say your parents are wealthy. Now they are aware that you are married, you've got your wife, but they have a will. And you are getting a huge stake from that will, but it's within their wish that whatever you get from the will, you don't share it with your wife right now. And at the same time, you are in sort of a community of property contract with your wife. How does the court interpret that?
So when, for example, my parents draft a will and they indicate that all that I'm to benefit from their will must not form part of my joint estate with my wife. Should it so happen that we separate, all of that will not form part of the joint estate. The courts will then take into cognizance or into consideration the terms of the will, and as such, everything that has been excluded by way of a will from forming part of the joint estate will not be part of the joint estate.
Okay. So it's just as simple as that.
Yeah, it's as simple as that. That the only condition to excluding an inheritance is through a will. When you have benefited or inherited assets through a will, and the will specifically, it must be as express as possible on the will. If it's not indicated on the will that such assets must not form part of your joint estates, they will then form part of the joint estate. The court will count them as being part of the joint estate.
Okay. How likely does this happen? Maybe as a last question. It's too complex even for my brain. I don't know how to explain this. But how likely does it happen in South Africa where Tony is married and with kids, Tony's wife passes on, and Tony gets a second wife to come on board, and second wife comes on board, gets married to Tony, community of property. Sadly, Tony passes on. Then the new wife kicks out Tony's kids from the house and bring in her own kids from elsewhere or family, and then basically Tony lost everything. How likely is that to happen in South Africa?
It is important to highlight or indicate that in the absence of a will, such estates are dealt with by what we call interstate succession. Interstate succession sort of looks at the circumstances in the context of the example you're using. When the wife passes on, Tony is entitled to 50% of the estate of the wife. The other 50% goes to the children.
Oh.
And when you get married to your second wife and you pass on, your second wife is then entitled to 25% of that 50%. The other 25% goes to your kids.
Right.
So your second wife, in essence, will be entitled to 25% of that. And the rest will be to the kids.
So hardly happens ever. So because I would see some of this cases being posted on social media, I'm like, how likely is this case to really be a reality?
It happens quite a lot, actually. It happens quite a lot. And it's important that the courts highlighted. There's quite a lot of judgments around that issue, and the courts have been clear about it, that in the event where there's no will, the wife passes on, you are entitled to the 50%. Remember, you are married in community of property, so it's a joint estate. You are entitled to 50% of the joint estate. The other 50% by way of interstate is then bequeathed to the children of the marriage. Mm-hmm. And should it so happen that you marry someone and it is in community of property, your joint estate with the second wife is the 50% only, not the entire 100%. Mm-hmm. And in the event that you pass on, your kids are entitled to their 25%.
Mm-hmm. Why is it easy to interpret the interstate, but a little difficult to interpret a case of customary in a case where somebody else dies than a wife, because you don't have any document to produce here? Then you are told, we don't acknowledge you as, and the claims that, well, you are here, but our child has actually intended to divorce you, and he had sort of communicated that, but it becomes difficult very often. And this is a case where mostly women go through, where they can't have access, to bury their husbands, and their husband's family becomes more tough. Because in this case, I'm also thinking, if we are to respect customary law, how about also much more of a recognition of the elders who are sort of present there and officiating the marriage in itself?
So to make it a bit easier, one of the biggest challenges that arises in customary law is that you'd find that it's not registered. Mm-hmm. And if the marriage is not registered, it presents challenge number one. Challenge number two, you'd find that when the wife comes to the front, or sometimes even the husband, when you approach the courts, the first element of evidence they request is a letter between the two families to confirm that the two families did engage at any point or at some point and agreed that you would be married to this person. Be it even if you had not concluded your lobola agreements, but you had started and there's an agreement on the table that this is how much we agreed on, and we will come back at a later stage to conclude this. Should it happen that in such a situation one party passes on, the remaining party is ought to be recognized as the partner or as the wife or the husband of the deceased. And in the event that such times where families fight and say, well, our child intended to divorce you, our courts rarely recognize such an intention, because a party who intends to divorce approaches the courts. Mm. And for as long as a divorce has not been finalized and a decree of divorce has not been granted, that divorce is not deemed to be final. So in the event that the family comes forth to say our child intended to divorce you, for as long as that particular deceased has not made it happen, such statement will not hold water in court. That person, as long as there can be evidence that indeed lower negotiations were held, there was a discussion and agreement, such a letter suffices to prove that there was indeed an existence of customary marriage.
In the case only one family writes the letter, but the other family refuses to write the letter?
I would say that rarely happens because remember the letter is written during the lobola
Oh,
negotiations.
right.
It's signed by both families in the presence of each other to say we sat down today, we agreed on this amount, or we agreed on this number of cows or cattle, and signed by these parties from this family and these parties from this family, and that's the letter that you can bring forth to the courts and say, yes, our marriage is not registered, but here's a letter confirming that we were indeed married.
But does it? Are you sure everybody does it? It's not from culture to culture.
I'm not quite sure if there are cultures who don't do it,
Okay.
but in most instances that I've come across so far in my years of practice, there would always be a letter. So the presumption, as it stands from my perspective, is that a letter may be concluded, and this is so because when lobola negotiations are held, they're held by parties of both families, whereby the letters to confirm that we sat down, we discussed the lobola of these two parties, and this is how much was agreed on, and at the bottom they sign. Such a letter can be brought to court as evidence of the existence of such customary marriage.
Does the court ever exist an unfinished payment? So, because in lobolas, people always speak about figures. And I know different cultures that would say, well, a man never really finishes lobola. You know, does the court ever entertain the fact that the lobola was not fully paid, therefore you cannot claim it does not?
Nope. So the court works on what we call the agreement. Remember, like I said when we started, that marriage is a contract. So when the families sit down, discuss and agree and do that letter, they may say, for example, they agree on 50,000 rands for lobola, and the first payment is 20,000 rands. Even if it's 5,000 rands and there's 45,000 rands outstanding, the most important point is that there is an agreement. There's a contract. There is an agreement on the table that has been signed that lobola is set at this value, so much has been paid, the contract has been concluded. And that is the most important element of what the court recognizes, because then that confirms the intention.
Last question, I promise, very last. This one, I need both your expertise and your critical faculty. Tony gets married, customary wise. I'm charged X amount. Part of the things that are often raised during lobola bride price is that you'd hear people saying she's educated, she'll cook for you, she'll give you children, and whatsoever. I'm not sure whether those reasonings, do they go onto the letter or they don't go onto the letter that the person has to give me babies. And then we get married, Tony pays X amount of money, extremely expensive, let's put it in just for the purpose of this case. Down the line, a year or so we divorce, I've never gotten the children and whatsoever. Is Tony entitled to demand his lobola money back?
Not on that ground. You can normally I take them as, I would say, semantics when people negotiate to say our child is educated, she will give you kids, she will do this and that, she will cook for you. We see those as semantics because when we get to court, what matters the most is that where was the contract concluded by valid or by competent people, your delegate, were they people of sober mind, did they agree? And if such an agreement was concluded, were you aware of it and were both parties aware of it? If that's the case, same ought to be recognized. But to come back to court and say, I want my lobola money back because they said this person was going to give me children and this person has failed to do so. Such a ground, I don't believe it will hold water in court because the evidence that then needs to be put forward is that the people who made that promise to you had expert evidence or scientific evidence that this person is able to give you kids. Now you'd have to prove that. And if you have said to them that they have failed they said to me that this person will give me kids, they must have sought expert evidence, but they have not, this person has failed to give me kids. The court will then ask you, where did you see that evidence that this person will be able to give you those kids? So like I say, they stay purely semantics, and they will not hold water in court. You cannot use that as a basis for that. I would assume, or I would believe, that in the event that you come to court and perhaps plead fraud, misrepresentation, misleading information, concealing of particular information, those are grounds which you can use because they are detrimental to you, they're prejudicial, they aimed to defraud you to a particular point or to harm you. Those are grounds you can use in court, but the other ones, those are purely semantics.
That's the legal aspect. Yeah. What do you think in terms of your personal view on this one? Because I'm thinking, obviously, many families are making business with their daughters. They don't come and say, we're making business. We know that it's either when I give the bride price, some of the money comes and help in a white wedding for those who embrace both the tradition and the white wedding. Or sometimes, we know that the families might take it and share it among themselves with the claims that we've raised the daughter and whatever the case. But some see that, as money-making scheme. So how would you sort of position that?
Well, my personal view in that situation is that it's difficult to determine which man goes where. And to come back and want to demand it from a personal perspective is purely unfair as well. You've had your time with their daughter. And what is your compensation to them for that time?
That response sounds like a future Chief Justice protecting your future career. I knew you were going to be political with me.
Well, I received a manifestation.
May it come to pass. Thank you so much, sir. It's been really great hearing from you, sharing with us. I really appreciate your time and your expertise.
No, thank you so much for having me, and I hope everyone who has been listening in enjoyed the show.
Do you want to maybe give your contacts out in case people would like to sort of contact you for whatever different reasons that they might have?
Yes, definitely. So people can get in touch with us by either going on our website, which is makgailainc.co.za. And there's a tab that says contact us there. When you send a message there, it goes to our emails and we'll then contact you. You can leave your name, number, and a short brief message of your issue, and then we will then get in touch with you. You can also contact us on our landline at 011-593-3285. I will repeat that, 011-593-3285. They can also send us an email at info@makgaila.co.za. That is without the ink. It's info@makgaila.co.za, and we'll respond to that email. You can just contact us with your number, name, and your brief discussion of your issue, and we will get in touch with you and arrange a consultation so we can see how best we can assist you. Our offices are based in Centurion. Our address is 269 Von Willich Avenue, Centurion. Our office park's name is Corporate 66 Office Park. Corporate 66 Office Park.
Amazing. Thank you so much, sir.
Thank you so much.
Visions and Tones, talk to you soon, and we are out. Cheers.
This is the Visions and Tones podcast with Dr. T.